Thank you to the American Constitution Society for sponsoring this opportunity to get together with some extraordinary people and to help discuss something of extraordinary importance coming up. The 2012 elections, as some of you may have heard, are around the corner. In 2008, we know that the electorate changed shape. There were still disparities based on race, based on ethnicity, based on income, based on education, still disparities between the most fortunate and least fortunate in terms of who came out to participate. But in 2008, those disparities were smaller than they have been in decades. Real positive progress in helping the active electorate reflect more closely, not closely enough, but more closely than ever before, the actual population governed by the officials that we elect. In 2010, we saw a step backward to more along historical levels where those sorts of gaps in the active electorate managed to manifest themselves. And coming into 2012, we now have pending questions about what the electorate will look like, driven in large part by what the rules of the game happen to be. We're here today to discuss those rules, to discuss some changes in those rules, new regulations describing who can participate and on what terms. And we have here an extraordinary group of panelists that I'm truly delighted to be sitting at the same stage with to discuss all of the changes, the new terrain that we face, some of the challenges that that new terrain has brought, and maybe even some of the opportunities that the new terrain presents. I'm going to introduce very briefly this extraordinary set of folks and then want to have more of a discussion about what the new regulations of the franchise look like this year, things we can expect, things we should beware, and particularly coming into the 2012 elections and beyond, how we can better structure the infrastructure of our democracy, really the rules and regulations that help set up every other policy that we as American citizens care about, how we can structure that to best reflect who we are. In particular, sitting immediately to my left, Nicole Austin Hillary, the Director and Counsel of the DC office of the Brennan Center for Justice at NYU School of Law. Immediately to her left, Secretary Natalie Tennant, West Virginia's Chief Election Official and the Secretary of State of West Virginia. Immediately to her left, Nina Perales, the Director of Litigation at MALDEF. Following Ryan Haygood, the Director of the Political Participation Group at the NAACP Legal Defense and Education Fund. And then Elizabeth Wydra, Chief Counsel at the Constitutional Accountability Center, an extraordinary group of litigants, of responsible officials out there very much on the front lines of determining what the franchise looks like. My name's Justin Levitt, former National Voter Protection Counsel for the presidential campaign in 2008, and now professor at Loyola Law School in Los Angeles, and it's my job to direct traffic and do very little more than that. I want to start our conversation today by asking Nicole to walk us through the landscape of some of the changes in the terrain we've seen most recently. What's taken us, what's new now this year and last year that put us on different footing in 2012 than we've perhaps seen before?
Sure. Thank you, Justin. First of all, I think it's important for us to understand one very key thing, that historically in this country, we have really been, since Reconstruction, a country that's been about opening the doors to our elections. The laws that we've passed, coming up through the Voting Rights Act, have all been about ensuring that as many Americans as possible have their right to vote and can easily do so. This is really the first time since that historical move that we have been a country that is actually going backwards, that is actually seeing states that are introducing laws that have the effect of making it harder for people to register to vote, making it harder for people to actually go and cast a vote, making it harder for people who've made past mistakes, like those who are formerly incarcerated, making it harder for them to actually become re-enfranchised. So this is a key shift in terms of our country and how we are dealing with our citizenry. So I think it's important to start this conversation from that point of view. From 2011 to now, we have seen a huge shift in legislation that has been introduced in the states and in laws that have actually been enacted. And I am not going to bore you with a lot of numbers, but I do have to share with you some numbers because the numbers tell a story. And I hope that many of you have had the opportunity to take a look at a report that the Brennan Center produced back in October of 2011, where we actually put together a compendium of information to really demonstrate what has changed in terms of state laws, in terms of the laws, the executive orders, with respect to voting and what those voting law changes look like. Often when we talk about this issue, we have a map up of the entire country. And if you look at that map in 2010 and the beginning of 2011, there's not much color to it. When you look at it now, and frankly, our report is outdated. For those of you who have seen it, you should continue to check our website because that's how quickly these changes are taking place. If you look at a map of the country now to see what states have enacted some kind of law that has the effect of making it more difficult for individuals to vote, that map is very colorful now. What we have now today is 23 laws and 2 executive actions that have passed in 18 states in this country. 180 bills were introduced in 41 states, and 47 bills are still pending in at least 12 states. So this is not over by any means. There are new laws in 15 states that could actually impact the 2012 election. There are 210 electoral votes that are at play. 78% of the total needed for the presidency. That means that in those states where these new laws have been enacted, 78% of the electoral votes that are needed for the presidency are within those states. So this is grave. This is really, we are at an emergency status here in this country in terms of looking at how our elections will be impacted. There are also states that have actually gone back in terms of progress that they had made previously. In Iowa and Florida, for instance, those were 2 states that had actually progressed in terms of what kinds of opportunities were being presented for those who were formerly incarcerated. Those states have actually rolled back the advances they had made for those individuals. So we really have a crisis, and it really is, I tell people all the time, this is really not about are you from a blue state? Are you from a red state? Are you Republican, independent? Are you a Democrat? This is really about our democracy and the fact that we have to protect the right to vote for everyone in this country, regardless of how you decide to cast that vote personally. So I'll stop there, Justin, because I'm sure that throughout the conversation we'll get into some more specifics about what's going on in some of these states. But in terms of the broad overview, that's what the numbers are looking like.
And it is a sobering view of the map indeed. I'm reminded actually that I have before we turn back to the substance, 2 other sobering thoughts. One, to remind you all to please manage your cell phones as if we were actually in a movie. And 2, for those of you that are seeking CLE, to remind you that this is one of the panels for which CLE is available. There are sign-up sheets outside. Please do sign in if you want to get CLE credit for this very important conversation. Now, with that extremely awkward segue, back to the conversation we were having. Nicole just presented us with sort of the geographic terrain and has noted that many of the rules for how we go to the polls has changed. And with all of the bills that she mentioned, is continuing to change, as she mentions, through this year and perhaps in many ways through the lead up to the election itself. Even laws can change in the very weeks before an election. I want to get into some more specifics about what sorts of laws those are, including some that we may not think of as changing the way that people exercise the franchise, the way that they cast their votes. Nicole mentioned felony disenfranchisement rules that have changed recently. Nina, I want to ask you in particular, what sort of laws are we talking about here? Not only the sorts of laws that facilitate or prevent people from getting to the polls and from casting a ballot, but also the weight of their voice in this process.
That's a great opportunity for me to talk about redistricting. Can you all hear me? And I will just speak for a moment. People don't think about redistricting as kind of vote suppression, but vote dilution really is a form of vote suppression. Every 10 years, those state legislatures that have the authority to redistrict can get up to some trouble in certain states, and in Texas, which is the example I will use, we had a release of the 2010 census, and the first thing that happened was reapportionment. Before we even really knew the extent of Latino population growth, the first thing we did know was that Texas had picked up 4 seats in the United States House of Representatives. So Texas was the big winner demographically. No other state got 4 seats. It was almost historic. And then right after that, in February, we found out that Latino growth had largely contributed to Texas picking up the 4 seats. There were very high expectations in the Latino community throughout the state that at least one of them, if not 2 or 3, of the new congressional seats would be Latino opportunity seats, especially because we had gained no seats in the previous round. So we were talking about a 20-year span with no new seats. And the legislature did get up to some trouble after debating hotly the question of how much representation Latinos would have and how much demographic change had been occurring. The legislature passed a congressional plan with no new seats. So it was a 0 gain. And people were really very, very upset about that, and we ended up going into litigation along with other parties. What we have right now is not an end to the litigation, but we do have some temporary plans for 2012 which have allowed us to have a primary, which is always good, and we will have a general election in the fall under these interim plans, and in those plans there are 2 additional Latino majority seats out of the 4, which was a lot of progress for us given that we were starting at 0. And the sort of the context or the frame I want to give for you about this is that in places where the electorate is changing very, very quickly, and in Texas, I will say, and throughout the Southwest, strong Latino growth is really changing things. We have a very young age structure. So we have a lot of young people who are born here in the United States who are turning 18 every year and becoming eligible to enter the electorate. And at the same time, because of Anglo age structure being older, we have people exiting the electorate, I guess is the most gentle way to put it, at the top end. And that would be demographically more likely to be Anglo. So the changes are very fast. And I think that redistricting is sort of one way for those in power currently to try to get the genie back in the bottle.
And as Nina mentioned, so redistricting happens after each census. It's really the baseline for giving weight to various populations. And as populations shift, every single state in the country, every local jurisdiction will redistrict its lines to frame which individuals elect which representatives. That's the baseline across the board. Every state on Nicole's map, you can light up for redistricting. Some changes for the better and some, as she mentioned in Texas perhaps, changes for the worse. That's the start, but not the end of the matter when it comes to participation. And Nina has also been involved in some various other issues that Texas has had. Texas certainly not lone among states in changing the landscape. In addition to the redistricting problem, there's now a pending controversy about identification restrictions in Texas. There's a recurring controversy about purging provisions in Texas. There's a recurring controversy about restrictions on who can register voters and how and why and in what context in Texas. And Texas is hardly alone in sort of hitting multiple avenues for the right to vote. Florida certainly joins the company. Some of you may remember Florida from some past elections and some of the controversies that arise there. All of these changes, or all of these falling back to more familiar patterns, happen in the context of big demographic shifts. And the question I want to pose to you, Ryan, to bring you into this conversation, is this new, or are we back to something that we've seen before?
Sure. Thanks, Justin. And I'd like to add sort of another layer to the discussion that Nicole started, which is sort of where is this all this coming from? And is this a new phenomenon in our democracy? And I think with respect to answering that point, William Faulkner provides for us a very nice quote. That is to say that the past is never dead. Indeed, it's not even past. And I think that that quote has special resonance with respect to our experiment with democracy, which I think has always been a contested one, one that's been characterized by periods of broad expansion of our electorate, followed swiftly by periods of swift contraction of that same electorate. And I think that if you won't mind me taking a step back into some of American history, I can provide for you a pretty salient example when looking at the African American experience. There's been no other democracy in the history of the world that I can remember or find when studying, where a democracy has sought to enfranchise a group of folks, then subsequently disfranchise that same group of folks, and then later re-enfranchise that group of folks. And I think this speaks to the African American experiment with respect to our democracy. Following the Civil War, for example, Congress moved swiftly to establish widespread black suffrage. Between 1866 and 1867, the percentage of black males who were eligible to vote shot up from 0.5% to 80.5%, a dramatic increase, with all of that increase happening largely in the former Confederacy. By 1870, the U.S. Constitution now featured two new amendments. Folks here know those to be the 14th and 15th Amendments, which enshrine the right to vote. And the first Reconstruction, which was a period of vast expansion of our electorate, was well underway. During this period, black office holding and participation shot up dramatically. Half of South Carolina's state legislature was African American. 40% of Louisiana State House was black, and 30% of Mississippi State House was black. And this is significant given that in these states there was previously no African American participation at all, much less any African Americans holding office. This clearly was a period of democratic expansion. But consistent with our theme, where there's expansion, there's also some period of contraction. And by the 1890s, just a generation after this great period of expansion, where there was expansion in black office holding and participation, Southern legislatures moved swiftly to extinguish this participation for the great majority of blacks. A House report for the 53rd Congress from 1893 to 1895 demanded that, quote, every trace of Reconstruction measures be wiped from the books. And so then a century of fierce struggle ensued, during which time, as folks know, having studied the Civil Rights Movement, people put themselves in harm's way, literally to move our country from this practice of high ideals and low practices, to move our country closer to its promise of equality for all. And this led to the enactment of the Voting Rights Act in 1965, which is widely credited with being the single instrument that ushered in a great wave of participation, a great wave of striking down barriers to the political process that has historically excluded so many from voting. And it also is credited with ushering a period in which Americans, to borrow from the late, great Michael Jackson, joined hands in a We Are the World moment and cast their ballots in a way that led to the election of the first African American to the White House. And this was no doubt a period of significant democratic expansion. So consistent with our theme, what's ensued next, right, is a period of democratic contraction. And we've seen that in these last few years most acutely. And I just want to share as I close that this is a response to two recent and very important developments, where states are now seeking to make voting difficult through the very channels that produced historic turnout in 2008. First are these unprecedented levels of political participation by people of color and many others in 2008. And in response to what Nina pointed out, a phenomenon we saw in Texas and many other states, in reaction to the significant growth by communities of color, as was reflected in the 2010 census. As to the first, one commentator described 2008 as the most racially diverse electorate in United States history. In 2008, voters of color comprised a record share of the electorate. The number of blacks and Latinos each exceeded an increase of 2 million votes, while the total share of white votes actually declined. With respect to demographics in America, one commentator explained that demographic trends confirm that America will soon be a majority-minority nation, with the Census Bureau projecting that this tipping point will occur by 2042. For Americans under 18, this commentator went on to say, this shift is projected to take place in 2023. Every child then who's born in the U.S. from here on out will belong to the first post-majority white generation. And it is in response to these voting and demographic trends which foreshadow a political landscape in which people of color will play an increasing role that this burgeoning political power has engendered a political backlash.
And from this demographic growth and some of the challenges that states are posing now to the richly diverse electorate, and particularly where the increasing diversity of the electorate threatens existing incumbents or threatens the existing power structure. One of the tools that we as litigators, that we as lawyers, that we as constitutional scholars have, one of the tools that has been put in place, Ryan mentioned, is the Voting Rights Act, extraordinarily credited by many as the most successful civil rights statute in the country's history, and provides a powerful both sword and shield. Some of the very cases that Nina was mentioning before have been brought under the Voting Rights Act, in particular sections of the Voting Rights Act, like Section 5, that targets particular communities with a history of abusing voting rights, and particularly abusing voting rights for our least integrated communities and communities most in need of protection. One of the new trends in the 2012 election cycle, and perhaps this isn't so much a new trend as a trend that's finally coming to fruition from those who've been planning it for a very long time, are threats to this very section of the Voting Rights Act itself, one of the strongest components of the protection regime we have for the right to vote that we've seen so far. Elizabeth, I want to ask you about this in the context of what states are doing to challenge individual voting rights and challenge the nature of the franchise. What are you seeing in these new attacks on the Voting Rights Act? How much of the Voting Rights Act is now subject to challenge, and where do you see those challenges heading in the future?
Yeah, thanks, Justin. So the constitutional law with respect to voting rights is very much at a crossroads right now, which is not coincidentally also the name of a report that my organization, the Constitutional Accountability Center, has put out. I think it's listed on your CLE reading list. But we come to this crossroads at a very crucial time, which, as we've talked about, there's burgeoning numbers of voters being included in the franchise, record turnout, and the fact that not only are some states trying to get at this through changes to voting, early voting, registration, purging, et cetera, but also by attacking the fundamental constitutional basis that Congress has used to protect the Voting Rights Act, most crucially in the Voting Rights Act of 1965. And so this preclearance requirement that Justin mentioned is being challenged as having exceeded Congress's enforcement powers under the 14th and 15th Amendments, which guarantee equality and equal citizenship, and in particular the right to vote free from racial discrimination. So for some of you who were at conferences in the past, this might seem a little bit like deja vu. And that's because in a 2009 opinion, the Supreme Court addressed this issue, sort of, in the Numudno versus Holder. Numudno is this horrible acronym that we've all used instead of saying Northwest Austin Municipal Utility District Number 1. But in that case, the Roberts Court was poised to strike down the preclearance requirement of the Voting Rights Act. However, the court backed off this precipice by ruling on a very narrow ground, narrow statutory ground. But the court will not be able to avoid this constitutional question much longer, and that's because in the wake of the Numudno decision, many, for example, in Alabama, Texas, South Carolina, Georgia, have brought direct challenges to the constitutionality. So there's no way out, no way to get a more narrow ruling. They present the question of whether Congress has the authority to enact the preclearance requirement to both block discriminatory voting regulations and laws and also deter them. I think that's very important. And I think that's important to keep in mind because precisely a lot of the progress that Ryan was just mentioning has been used against the Voting Rights Act. Opponents to the preclearance requirement have said, you know, look, the coverage formula for which states must go through preclearance is based on outmoded ideas. This is sort of, stereotypes about particularly the South, which is where the concentration of states who have to get their voting regulations or laws pre-cleared by DOJ or a three-judge federal court panel lie, and say, look, we have all of this progress. So the coverage formula and the pre-clearance requirements are a burden on state and local government, and they're no longer justified by current needs. We have the nation's first African-American president. We have record numbers of turnout in communities of color. And so, this isn't justified by current needs anymore. And so I think the court will, talking about when they will get to this crucial question, there's a case, Shelby County, Alabama versus Holder, that was decided last month in the DC Circuit. The panel, including Judge Tatel, who wrote the majority opinion, and a George W. Bush appointee, they upheld the constitutionality of the preclearance requirement of the Voting Rights Act and the coverage formula used in that. But the folks who are challenging it immediately said that they would petition for certiorari in the Supreme Court. So I think we could be seeing this come to a head probably next term.
So we've got changes based on the last round of redistricting. We've got changes based on the diversity of state laws, our massively decentralized election structure, and the fact that even for federal elections, the laws are vastly different, not only state by state, but county by county and poll worker by poll worker. We've got revised challenges, renewed challenges to some of the more foundational tools that we have to resist the most racially and ethnically charged of the changes we see. And now, to bring you into the conversation, Madam Secretary, all of this change comes with you on the front lines of trying to make sure that the people who are eligible to vote and wish to vote can, and that it counts. And so, given all of the change, given all the flux, both that you see and that you receive from your legislature, what is it that you feel is the biggest challenge that you have on the front lines in responding to this change, both to change that you might like and to change that you would prefer not to see?
Wow. It makes our job very interesting, and you probably hear a lot of sports analogies coming from me. There is no one single challenge the way I see it. So that means that I'm playing zone defense instead of man one-on-one defense. And partly is defense, which also makes it difficult for me personally as a Secretary of State, who is also a forward-thinking Secretary of State, who wants to implement measures that do make ballot accessibility greater, whether it's for a voter or whether it's for a candidate. And so I come from many different angles on this, and I first off have to say that, as I speak here today, I speak for myself and not for any of the colleagues who are secretaries around the state. I'm part of the National Association of Secretaries of State. So when I say NAS, that's what we are, and I was asked to come here and represent NAS in that aspect. There are some of us who probably believe what I believe. There are some who don't. And we do have, we're a bipartisan group, but we also have debate back and forth, which has brought us all forward. I also must say that, it's really great to be the only non-lawyer on a lawyer panel. It's awesome. It's just awesome.
Most people don't think
Don't
that.
know what it means. We'll see. We got another hour to figure this out. But in saying that, too, the Constitution, I guess I can't say I've used it in so many ways, but I defend it, I uphold it, and I stand on it because it's the only thing I have to. When it comes back down to how we're implementing laws, and so, I'll go a little bit back and forth, and then we'll get to more details. And I think it's interesting. I'll tell you a little bit more about West Virginia. We are not one of these Section 5 states, the pre-clearance states. And as an election official, that is wonderful. That is wonderful as someone who wants to be forward-thinking and say, can't we implement this? But at the same time, I understand the need for it, too, if we're going to put arbitrary barriers in front of voters. So with that point being made, as we're on the front lines, it's where I am coming from. I look at it from both ways as having to play defense against a lot of, I guess I'm the reactionary. I sit here and listen to Nina, and I write down, yeah, one of my fighting angles is that when redistricting and the work of the legislature is enacted and people don't like it, guess who gets sued? Secretary of State. And as part of my duty in the West Virginia Constitution and West Virginia Code, I defend, especially what the House of Delegates had put into place. I was also part and able to step back a little bit from another lawsuit that is before the U.S. Supreme Court as well, but we were able to continue with the map as it had previously been. So I have fights on many different angles. Another reactionary that I have is with all these other states that are putting in place voter ID laws. Then there becomes a response that, yes, we've fought this in our I'm probably part of one of those numbers. The state is probably part of one of those numbers of legislation that was put into place. But when it gets down there on the front lines to the people who are voting, when they hear this, we had our May primary election back on May 8th. We had so many people calling saying, so I need to bring my voter ID, correct? I need to bring a picture. Well, some of the intentions have already been met. Because if you've already caused people to question of whether or not they have to bring a picture ID, you do not in West Virginia unless it's your first time voting and you've registered by mail. You don't have to do that in West Virginia. We match up your signature. And so some of those intentions of putting arbitrary barriers have already been accomplished. And it's frustrating to me because I am about access, I'm about access for voters, and I'm about access for candidates as well. And I'll stop here and be able to add some more as we continue the discussion. But that's what happens when we talk about all of these. It becomes reactionary, whether a state is personally involved in it or not. We still have to deal with the reaction of what a voter might see, what our lawmakers might. And so I really am playing defense at the same time trying to be forward-thinking.
And I love the zone defense metaphor, not least because it can be hard to tell in a zone defense where to focus.
Right.
You have
Right.
somebody, you have so many people running through the
Right.
zone.
Mm-hmm.
It gets very difficult to continue, extend, and/or massively misshape the metaphor to follow the ball. So given that, I want to bring a different metaphor into play, and that's Buckminster Fuller used to talk about not only mechanical engineering, but social engineering in terms of the trim tab, something he called the trim tab. It is the way you move an ocean liner. So you can't actually turn the rudder of an ocean liner. It's just too big. But you can turn the little valve on the front of the rudder that begins to reshape water pressure to help move the piece of the rudder, to help move the rudder as a whole, to help move the ocean liner. And that one little piece, the trim tab, is the point of maximum leverage on the rudder to actually turn the ship in the direction you want. In this upcoming election cycle, and this is really a question for everyone, what do you think is the real trim tab? Where should the real focus be? There's a lot of attention to a lot of different either restrictions on the right to vote or opportunities. Where should we be focusing? Nina.
I've got two. And they both relate to cases that MALDIF is working on right now. One is I think one of the small changes that can make a big effect is voter ID. And the stricter it is, the worse it is. I was talking to you about a legislative session in which we did redistricting in Texas. We also passed, not coincidentally, the toughest voter ID law in the country. It is a hard photo ID requirement, meaning that what Texas did was took its existing voter ID law, because most states do have some kind of voter ID law, and in Texas you could show a photo ID or your voter certificate, which is special because it comes to you and it is free. So that was taken out along with all the other non-photo IDs that you could show, so that what we have left is driver's license, passport, military ID, And of course, one of our treasured documents in Texas, concealed handgun license. And
Is there a picture on the concealed handgun?
Yes, ma'am, there is.
Because in West Virginia, we have no picture.
right, and then they have some citizenship papers, but they call it a certificate of citizenship, which they don't even know what that is because it doesn't have a picture on it. But you could, if you didn't have those, but you did have a NAT certificate with your picture on it, you could use that as well. So by taking away things that you could previously use, they've created a whole group of registered voters who now don't have anything. And so, for example, two of my clients are young women. They just turned 18. They just graduated from high school, the pride of our community. They're both going to college on scholarship. We're so happy and proud. They just registered to vote. They have their voter certificates. They have school IDs, and in the fall, they'll have their college IDs. But the college ID is specifically excluded from Texas's voter ID law. So you can't use your picture, even if it's state issued. If you go to UT or A&M and it is in fact a state issued photo ID, you wouldn't be able to use that. So we have these two young women who are very interested in voting, who do not have voter ID, for whom voting will now involve gathering a whole bunch of different documents from mom at home and going down to the motor vehicles department to wait upwards of 4 hours to get a free ID with their picture on it. And you know, for all of us, even those of us who are high propensity voters, it's always that day of the election kind of a balancing act. You know, I've got 3 kids. I know that I've been at work all day, so now I have a fairly small window of opportunity. If I'm voting on election day, the polls close at 7, I got to pick up. I got to drop off at dance. I got to pick up from sports. I got to get dinner on the table. Everybody makes these calculations on election day, whether we're going to be able to get out there and do it that day, right? And sometimes you just hit the tipping point where you're not going to do it. And so these young women that I'm talking about, they don't have driver's licenses, they don't have a car. Dad works all day. Mom is the sole caretaker for elderly grandma. Now they're going to have to figure out some way to get down to the motor vehicles department on some particular day, or do it from their college campus in the middle of classes to sit and get the ID. And in Texas, with this particular class of voters, I think many will not.
Is there something about the ID restrictions, just while we're on the topic, that makes it categorically different from all of the other hassles of voting as a regular basis? So there are lots of regulations governing voting. What is it that makes this special, or is it special at all?
Well, I don't have to do anything else for 4 hours at a DPS to be able to vote. I mean, this is unlike any other requirement. And Texas has an early voting period and early voting polling places that are in malls and big grocery stores. And in some ways, we've moved towards making voting much more accessible. You could sort of vote on your way to do something else, which is fantastic. But now we're sort of turning in the other direction and now causing people to have to do this big, gigantic thing, even if they have the documents. It's a pretty big commitment to be able to vote. I think it is significantly different. And by the way, there was an effort to try to do a signature matching bypass for people who didn't have ID, who could sign an affidavit, and then that signature would be compared back to the signature on their voter registration application, which is kept on file by the county in a hard copy, and it was soundly defeated, along with amendments to do specific minority outreach and education on voter ID and lots of other things that were suggested to try to soften the requirements in Texas. So this was very strongly aimed, and of course wrapped nicely in a little baked outside shell of anti-immigrant rhetoric, because the purported purpose of this is to stop non-citizen voters. There's no evidence of non-citizen voting in Texas, but of course the rhetoric that drove all of this was, and of course one of the legislators who was asked what evidence she had of non-citizen voting said there was a voter at her polling place who didn't speak English. She's a Spanish-speaking lady. And of course that is resounding evidence of non-citizen voting. And so you'll notice the bleed from the idea of somebody who's not qualified to vote because they're a non-citizen over to somebody who's simply Spanish-speaking, or somebody who looks like they could be Spanish-speaking, or somebody who identifies as Latino. There's really no good boundary there when you get into the Texas legislature.
I'm sorry.
I just wanted to say quickly, I think what Nina is just, you know, by connecting this voter ID requirement with some of the issues that we have, you know, in Arizona's SB 1070, Show Me Your Papers law, it's
similar.
a problem for our basic American values to, in both the show me your papers just for existing in Arizona and in order to exercise your crucial fundamental right to vote in the United States. And we've had since the, as Nicole mentioned at the beginning, since Reconstruction, we've had this progressive arc of history that one of the great things about our chronological Constitution is you can see this progress written into the Constitution over time. And in the discussions over, the debates over the ratification of the 15th Amendment, one of the framers commented that the irresistible tendency of modern civilizations is in the direction of expanding the right to suffrage. And so I think that all of these, this is sort of a bigger picture comment, but I think that the threat to our values and sort of fundamental values of the country with all of these attempts to restrict this foundational right should be very concerning to everyone because it threatens the most basic values and ideals of our country.
Ryan, what do you think
Sure.
is
I was just going to add,
important
to your
feedback?
question about sort of which ball to focus on. I think that, what the experience of voting rights litigators has been most recently, and I think if I see there's some in the audience, you could tell who they are because they're bleary-eyed. and that's because this season for us has been nonstop, focusing on all the balls. And so both Texas and South Carolina sought to pass photo ID measures that were as bananas as Nina described. And those are both the subject of litigation under Section 5 of the Voting Rights Act. They're each seeking expedited review of their photo ID measures so that they can be used in time for the 2012 elections. And so there are trials scheduled in those matters in July. And so we've been moving at a breakneck pace. What's been fascinating to behold is that all of the civil rights organizations are activated. So we have these conference calls with 6 or 8 national civil rights organizations in Texas and in South Carolina. Also interlaced with the civil rights organizations are firms that are lending their resources as well. And the Department of Justice is vigorously fighting against these photo ID measures in these 2 states. In Wisconsin, which recently passed a photo ID measure that would disfranchise 70% of African-American men in Milwaukee. There are a collection of civil rights organizations there fighting back against these photo ID measures in places like Florida, where the state sought to enact a pretty robust effort to make voting difficult at various stages in the political process through the very channels, by the way, that allowed for historic turnout by people of color and other voters in 2008. There is a team of civil rights organizations, national organizations, and again, firms, and the Department of Justice fighting back against those efforts. And there's actually an oral argument this coming week, Thursday, here in D.C., to determine whether together those laws are harmful, or the term of art is retrogressive. And just this week, the Department of Justice and 2 civil rights organizations, I want to say the Lawyers Committee and the ACLU, filed an action against Florida for this voter purge program that they recently employed, which is within 90 days of the election, and that matters because federal law prohibits purging in the 90-day window. But Florida was like, well, if we didn't get all the voters out that we wanted to in those other measures, here's one more. Right. And the response, again, I think, our theme is that the Democratic experience has been one that is characterized by periods of expansion swiftly followed by periods of contraction. But in that contraction, the history also always tells us that there are folks who decide that the contraction won't happen on their watch. And so I think what's been encouraging to behold here is that there are lots of lawyers, civil rights litigators, people in law firms, the Department of Justice lawyers who've decided that they're going to do their best, even if it causes them to lose and forsake sleep, to ensure that that doesn't happen on their watch. So I think these photo ID cases in Texas and South Carolina are ones to watch, because if we are able to prevail in those actions, it'll send a message to the other states about the foul nature of those practices.
And by the way, just one quick interlude. As some of you walked in, you may have seen the Election Protection Coalition outside. I think they've been tabling throughout the conference. This is one way in which people who are interested in learning how they can participate, how they can help, can affiliate with the effort to make sure that those who are eligible and want to vote can and that it sticks, they are not only mobilizing for Election Day in order to respond to voters, in order to give information, the right information about where to vote and how, but they've also been involved, and some of the constituent organizations at this table are also pivotal members of that coalition. They've also been involved in some of the fights leading up to Election Day on how to ensure that the franchise is effectively protected for the population. It's another way to lead directly off of what Ryan was talking about, that people have been able to get involved, whether they're experts on the topic or whether they're relatively new to it. Nicole, you had wanted to mention, I suspect, this is not the first time that Florida has been caught up in purge trouble.
No.
And I know that the Brennan Center's done an awful lot of work on voter registration as one of the trim tabs out there, as one of the main points of leverage. Do you think that that's one of the real other concerns or opportunities now and going forward?
I absolutely think it's one of the real opportunities. If we can stop some of these entreaties that are happening in the states, these last-minute entreaties, if you will, because folks need to be really clear about this. In Florida, the purging that is taking place is happening really at the last minute. You know, I'm sure you've all heard in the news, but there are regulations that determine when states have to make these kinds of changes. And Florida is not within the time frame that they were required to make these changes in. So attacking, or rather defending against these kinds of last-minute moves in states like Florida is going to be particularly important. But another thing I want to bring up too, Justin, is this. Both Ryan and Nina talked very articulately about what I like to call the 20,000-foot level, where we lawyers work. We work on the litigation, we work on the advocacy. But something that's really key and important to remember is dealing with the individual people who are around the country, public education. It is so key as a component to how we deal with these issues. You know, many of us are on panels like this consistently right now, because as we've said, there is a serious ongoing threat. What I hear consistently when I'm talking to legislators, when I'm talking to faith-based organizations, community activists, is what information do we need to arm our constituents, our parishioners, our citizenry? So that's another very important thing that the lawyers of the legal community needs to do. As Madam Secretary was saying, she has voters calling and saying, do I need an ID? People are confused. People need to understand that this is not just about voter ID. This is about a change to absentee voting. It's about a change to early voting, to same-day voter registration. All of these issues are at play, and it's really important to educate the citizenry about what are the specific changes in your individual state. So organizations like the Brennan Center, the Lawyers Committee, we are doing things to consistently update our website, sending out voting newsletters every week so that people know, here are the changes that are taking place. Here's what you need to know about what's happening in your particular state. Educating the voters about what they need to know, about what they need to do to respond to changes that have happened in their state is so key. So for instance, if there is a voter ID law that's been passed in your state, and I know, as Nina was saying, it's very difficult for people to adhere to some of these new requirements, but helping people to know, where can you go to get this voter ID? What are the hours? What is the cost? Those are going to be key things in order to arm voters so that they can at least be in a position to respond to some of these changes. That's going to be key. So even though I know we're all very smart lawyers in the room and we look at the litigation and all these other tools, it's important to remember the public education piece.
If I could follow up on that, that's
Please.
Exactly what I was going to say as I sit here and listen to these lawyers. I sit and think,
She means you.
yeah,
It's not such a bad thing.
I sit and think, no, I need them, believe me. I sit and think, and this is what I have written down, that your battle is in the courtroom for voters and this war on voting. My battle is at the table, the kitchen table. It's summertime. It's at the picnic table as we gather around and we think about, and West Virginia is a small state. I'm well known. People don't call me secretary. They say, Natalie, what's Natalie doing? Well, it only makes common sense, because here's what becomes part of a battle for me also is, you think, well, why wouldn't you use common sense? And this is where I think we need an understanding of those voters, that Well, why wouldn't you have to have an ID? You have to have an ID to buy a pack of cigarettes. You got to have an ID to drive. You have to have an ID to buy beer. Why wouldn't you have to have that for voting? Well, then Natalie comes back and says, well, that's a privilege. It's not a right. It is a right to vote. And when I start to make these same examples, because I also make this example, we in West Virginia, when I speak to young men and women, I talk about the Vietnam War, and you were old enough to die for your country, but you weren't old enough to vote in your country. And Jennings Randolph, the U.S. Senator from West Virginia, fought and fought and fought. And it began, I think, during World War II, but to lower the age from 21 to 18. And so I try to touch on that. Earlier this week, you all have boy states and girl states in your state. I made these girls hold their hands up for at least 5 minutes. They couldn't do it, these young kids, but isn't that what women suffragettes had to do, especially those who were treated extremely? And so I try to make those points one-on-one that, yeah, you have to have an ID for some things, but you don't, it's a right to get to vote, and we need to make that accessible. So, with your point made, I don't know what people like, or maybe don't like as much, lawyers or journalists, because that's my background. I'm going to fess up right now. And so what I do is go out on the front line and try to have that communication. And we do that through webcasting, because we have these technologies. West Virginia is a rural state, but we also have in some pockets good internet. We're getting better. But why not do webcasts, videos? We have polling places where you can find your polling place. Just put your first name, your last name, and your date of birth. We have tracking for absentee ballots that we're pushing. I also want to say, for those of you across the country, go to NASS, N-A-S-S, I told you about NASS.org, and there is an app that says, Can I Vote? And it talks about all the different requirements for all the different states. So that is an important aspect. And if we can pull all of this together to let people understand, you know, I still have the battles. My husband, my daughter are sitting back there. He's a Navy reservist, spent 7 months in Afghanistan. Military voting, we haven't even talked about that.
Oh,
military
that's
voting.
Right.
The
That's right. I'm going to put that down.
Of that. Write that one down. And I'm proud to say that West Virginia led the way in a pilot project for online voting for our military members. It was successful. I take hits, though, on panels like this, Nicole, where people want to question how well, but it was very successful. And when you have someone who is sacrificing, and they're sacrificing their family, their time, and putting their life on the line, yeah, they want to be able to vote online. They want to be able to do that. And then also, we haven't talked about, well, this is more my angle. I, as a state level, you know, yeah, I'm on the front lines, but not as much as the county clerks are on the front lines. They have a lot of responsibilities, and sometimes what I see is a bigger picture that needs to be done. They haven't incorporated it yet on their level. So that's another aspect of talking about, you know, we can talk all the courtroom and all the litigation that you want to talk about, but when it's somebody who has 2 or 3 people working in an office for voters, because that's that little section of their county clerk's office, it's hard to make that connection. So that's where I try to come into play.
I wanted to actually pick up, because I didn't get to talk about the Florida voter purge or the other thing. Just to close the loop on the Florida voter purge, Latinos are 14% of the voter registration. In Florida, they're 61% of the people who've been challenged under the purge. And the purge that I'm mentioning is the one where people are getting letters saying you're registered to vote, we don't think you're a United States citizen, you need to come in and prove up your citizenship or we're going to take you off the voter rolls. So people who are U.S. citizens and are registered to vote are getting these letters. About 2,700 of the letters have gone out so far, and over half of the people who are receiving the letters are U.S. citizens who are now going to be forced to go in. And, you know, your naturalization certificate says don't photocopy this document. You know, you're going to be a criminal. So I think a lot of people are going to feel that the burden is to essentially register in person. And we thought we had gotten rid of in-person registration requirements some time ago, which were, you know, endemic throughout the South in the past, but they've come back in. And the reason that so many naturalized citizens get picked up in these purges, and I'm so glad I have a captive audience and at least one Secretary of State, is that a lot of people get their driver's licenses, and when they get their driver's licenses, the proof of identity or the government-issued proof of identity that many people use is the green card or the legal permanent resident card. because you don't have a U.S. passport or U.S. birth certificate. So you're a legal permanent resident, you go in with your green card, you prove up your ID, you get your driver's license. Then you drive around for years, and you do not know that the Motor Vehicles Department has made a notation in their records that you showed a green card to get your driver's license. 7 years later, you're eligible for a naturalization, or even shorter amount of time. You naturalize, proudly take the oath, wave the small flag, whatever. You encounter a voter registration table outside the Nat ceremony, if you're lucky. Please send those folks. And then you register to vote, and it's such a proud moment. There you are, you know, it's your adopted, you can imagine, right? Fill in the blank. I won't get all emotional about it. And then the next thing you know, somebody is trying to match up the voter registration rolls with the driver's license records in the state, and they're going to flag all of these folks, which leads me to the registration restrictions that we're currently litigating in Arizona, which in 2004 passed a proof of citizenship requirement, which was a documentary proof of citizenship. So in order to register to vote in Arizona, you have to show a document of some kind or another to prove you're a U.S. citizen. And many people who use their driver's license number to do that get caught up in this driver's license matching process, and that includes some of my clients who have been prevented from registering to vote as newly naturalized citizens. And I wanted to talk about the Arizona case, because you think I do everything and only in Texas, and we litigate around the country. My boss is over there, and I know he's mad at me for talking too much about Texas. So
You just cleaned that up.
yes, I'm cleaning. I'm rapidly cleaning. Everybody, you know who he is. Just go over there and tell him I love the rest of the country besides Texas. Yeah, he's the one over there. So anyway, in Arizona, you can't even use the National Voter Registration Form postcard to register to vote if you can't prove your citizenship by putting in some number like an Arizona driver's license. You can't use the military federal postcard, the FPCA postcard, to register to vote in Arizona. And the whole purpose of the National Voter Registration Act in this postcard part of it was to get past all of these hurdles that many states had put in the way of voter registration. Congress said, we're going to have one uniform, seamless, prepaid postcard. And if you fill that out, states, the statute says, are required to accept and use the federal postcard application for voter registration. And to just loop it back around to the Constitution, the litigation that we're involved in, which is just like, it's just so frustrating, because it's so clear that the federal law requires Arizona to accept federal postcard applications for voter registration, whether or not they fulfill the additional documentation requirements under state law. But we lost this case at trial. We lost it the first time in front of a 3-judge panel. We won it the next time in front of a 3-judge panel, which included Justice O'Connor, who during oral argument said, does anybody dispute what accept and use means in this context? Because this is a preemption case, right? This is a supremacy clause case. And then won it again en banc, and Arizona just moved this week for a stay in the Supreme Court, which Justice Kennedy granted and ordered us to submit our briefs on Monday. So for all y'all who think, just appellate law is all sexy and everything, and forget about all that trial work, we're there now. And so we may see the court grant cert on this case. They're going to petition for cert later in the summer. And the whole darn question is simply whether Congress had the right to mandate the states to do what exactly they say in the NVRA, which is accept and use the federal postcard for voter registration.
There's so much more that we could talk about going into detail on any of these subjects, and part of having to play zone defense is figuring out which subjects to zero in on. Rather than my setting that tone, I actually want to use this time to turn it back over to you. You tell us what we should be going into more detail about. So I'd love to take questions from the audience. We've got about half an hour left. I'm going to ask that these really be questions rather than 5-minute speeches followed by a question mark. In order to do this, we do have a mic that is wandering around and we'll find you. Please do wait for the microphone because we're taping and we'd love to preserve your questions for posterity. We'll start right here up front. Yes, ma'am.
Hi, I'm Sarah Cherry from Columbus, Ohio. Thank you. This is an excellent panel. I am interested, I could ask so many questions, but I'm really interested in the NVRA's remedies for voters who might have registered at like a library or some non-traditional place. I believe there's something in there about if you are not on the rolls on election day that you can say that, sign some affirmation of some sort that you did indeed register. I don't think this is used very frequently. I haven't read much about it, so I was wondering if any of you had thoughts on that and other ideas for just getting votes counted after they're cast.
Any takers on the protections the NVRA does and potentially does not provide?
Well, I can say a little bit about that, but more, maybe not so much NVRAs as also the HAVA Act too, and provisional ballots that are used in that manner. If you say that you're registered and the provisional ballot, you vote provisional ballot, and then at the canvassing board, this is the way it works in West Virginia, the canvassing board will then look at that, and perhaps your registration has come in time. Now, also one of the requirements for NVRA in conjunction with the DMV especially, is that, and when you register at the DMV, which I thought was interesting on what you said, you are only required to have to fill out your information once. So I don't know if I'm going to self-report here or not. You say, you fill out for your DMV to renew it, here's my information, they ask you, would you like to register to vote? And some cases they will say, yes, I would like to register to vote. Oh, well, here's your voter registration card. They're, under our NVRA, you should only have to fill information once. So it should merge, I guess is the word I'm looking for. So what we're trying to do in West Virginia is use online voter registration that would ask, as you're on the internet, you filled in your information, give permission if you're registered with the DMV to use that signature. It wouldn't be your wet signature, but it would be what is stored. That saves time and money for our office and for the county clerks. I'm not sure that answered your question completely, but that's part of perhaps maybe provisional ballot that you're thinking of. I don't know if anybody else wants to.
Anyone else want to wade into some of the other protections that the NVRA does provide for people who might or might not know where they're registered or registered at the right place?
Well, maybe not so much where you're registered or not registered, but NVRA goes back with the, I don't like to call it purge. I call it list maintenance for, well, it is. Well, it is, because for me, and we are facing some of that right now in West Virginia, and this question in my mind, Ryan, I can't get out of my head is, where is this all coming from? And it's coming from different areas. Well, the fact that it's 2012 is a good example of where it is coming from, and it can be a political aspect. Two of our counties, and it's also coming from the fact that we just had the census, and I don't know, this is something that takes place across the country. If you ask your secretaries, you ask your county clerks, you have a disproportionate number of the census when the census numbers comes out as compared to those who are registered to vote. Some counties in West Virginia, 2, 3, we knocked up to 3, have over 100%. So people will automatically say, well, there's going to be fraud going on there. Well, NVRA allows for inactive to go from inactive, or from active to inactive, and you have to wait 2 federal general elections. So it is going to take a little time to have list maintenance on those voters. So that's another aspect of NVRA, and that's why it's interesting, and she's exactly right. How all of a sudden did this voter cleanup come, or list maintenance come in Florida? For us, you have to have every odd year, you have NCOA, National Change of Address, that you match addresses with your voter list, with your postal service. And so that's what we have to keep track of. We've been working on this. We have been threatened. I'm sure you all are familiar with Judicial Watch, and so some of these counties in West Virginia have been threatened also, but it's something we've been working on.
And the NVRA really, just to close this out, it has 2 parallel provisions that the Secretary has mentioned. One, encouraging different ways to enable people to get registered. Anytime you have a public service agency, to have affirmative outreach to individuals. That's something that's been dramatically under-enforced in the past. It's something that private organizations have had to really step up and bring suits in order to make sure is coming about, that states are actually upholding this mission. The second provision of protections. So now that you've gotten people registered, what protections are in place to stop people from being pulled off too rapidly or too precipitously without good information. That's some of what we've been talking about with respect to the limitations on timing in Florida, with respect to limitations on accuracy. Those are also protections the NVRA sets forward. Very important to keep in mind in the constitutional context. It's another guarantor that people who are eligible to vote and want to vote will actually be able to do so in the upcoming elections.
I just wanted to add that this discussion reminds me of sort of Nicole's important point about voters empowering themselves with an understanding of whether they're registered to vote and what their polling place is. And this struck me as I was thinking about these photo ID and other litigations. These states have passed, like Texas, South Carolina, Florida, have passed these measures that make voting more difficult, but they expended most of their energy in getting the laws passed and very little energy in thinking about how to actually implement the laws and educate their own voters about how this would happen. So Texas and South Carolina, Florida, are having trials on their on their voting measures very soon. Florida this week, Texas and South Carolina early July. If there's a ruling in these three cases from the court, say by August 1, they would seek to implement these laws very quickly, and voter registration would close in 2 or so months after these laws, assuming they're victorious, are implemented. And so it's very difficult to imagine how these states could adequately inform their citizens in a span of 2 months or less about the new voting changes and what would be required to satisfy them. And so I was struck by Nicole's point about the need, as a very practical need, for voters and people in this audience and others to think about those people in their spheres of influence, whom they can impart this important information while these litigations are ongoing, so they're empowered with an understanding of what their rights are, whether they're registered, if they are registered, where they cast their votes, their polling place is, to ensure that their votes are counted, and they don't have to rely on a provisional ballot. There's always a dangerous space with provisional ballots. People cast those, they think that their votes actually counted. They often are required to follow up with the documentation they missed on the day that they voted, and those votes aren't always counted. I think Ohio is a very good example of the way in which that happens, election cycle after election cycle.
And one thing I just wanted to add, Justin, and I don't know, Ryan, you may want to add to this, but another piece of recent litigation when we talk about NVRA and how NVRA is meant to protect as one of its prongs, there are even some states that are now doing some interesting things, such as saying, well, we know we have to offer you the opportunity to register to vote when you actually come into into DMV or into one of the social services offices. But if you perform any of your actions online, then our duty is not necessarily the same. So it's important for people not to only look at the protections that are afforded and what the responsibilities of states are, but also to look at what some states are doing in some very ingenious and creative ways are doing to circumvent those regulations. And I don't know if you want to add to that. And one last thing, Justin, and I hope some of the questions are going to be about this. Often these conversations can feel very doom and gloom because we are under pressure. There is a lot going on. But I hope some of you have questions about opportunities, because we should very much be looking ahead. We should be looking at 2013 and what kinds of things should we be putting in place now to prepare for 2013, because this stuff is not going away. And it's not the kind of stuff that we need to be saying to ourselves next year like, oh, I didn't know it was coming. It snuck up on me. The writing is on the wall, and we need to be thinking prospectively about some things that can be done. I just wanted to add that.
So let me take the opportunity then to ask you that very question. Quickly, what should be tops on the menu after November? So there's lots of concern leading up to November. After November, what should be tops on the menu? Proactive change.
One of the things that I have to talk about, and many of you have probably heard about this, but the Brennan Center has a policy proposal called voter registration modernization. It is a policy proposal that would, in a very major way, reform our voter registration system. It has various components. One, it would ensure complete and accurate voter rolls. It would shift the responsibility away from the voter onto the government, such that once a voter is registered in his or her state, no matter whether they move to a different county, to a different part of that state, that registration will follow them. It will also use existing technology that already exists in these states, and it will ensure that these systems are upgraded. And it could have the possibility of bringing 50 to 65 million eligible voters onto the rolls. This is extremely important. And we have some staff members in the audience from congressional offices. Congress has very much been focused on this policy proposal. A bill was introduced recently called the Voter Empowerment Act. And one of the hallmarks of this act is this voter registration modernization proposal. If such a proposal is actually enacted, it would really change the way we look at voter registration in this country, and it would really close the doors with respect to some of these opportunities that some states are taking to make it more difficult for voters to register to vote and actually stay on the rolls. So I would urge us to really think strongly about that kind of forward-thinking policy proposal as one option.
Anyone else opportunities for the next year?
Yeah, I just wanted to piggyback on what Nicole was saying, which is that Congress really can be a focus of change in this area of voting rights. Even with my previous comments about how there are challenges in the Supreme Court to Congress's ability to pass the preclearance requirement, it's not because Congress doesn't have that authority. It's because the conservatives on the court question the record that Congress has created, despite the fact that it's 15,000 pages long. I don't really know what else they want, but you know, it's important to remember that Congress is given this authority to enforce voting rights in across the 6 voting rights amendments, to enforce their guarantees of political liberty through appropriate legislation, and that should, if the court interprets it properly, give Congress significant leeway to enact these measures that are both protective of the rights we have and go further to create new opportunities for better access to the franchise.
How about down in the States? Opportunities in 2013, Nina?
Well, just because a lot of our focus is on young people who are turning age 18, a state-level initiative is to incorporate into high school civics classes, particularly for high school seniors, a section on voter eligibility and your ability to vote. I do not know why high schools are not registering their seniors before they graduate. In Texas, most of our seniors do turn 18 before they graduate because of the date set for when you get to go into kindergarten and the first grade. And so, you know, Texas, of course, vigorously resists doing this, as they do resist notifying people when they go off paper that they've recovered their right to vote and all the other things that Texas resists. But if it's possible to work in your state or to be conscious in your state about whether high school instruction for seniors includes instruction about eligibility requirements, because it's very important for people to only register if they're eligible to register. If a high school senior turns 18, but he's a legal permanent resident, then, you know, unless his state has non-citizen voting, he probably, you know, he shouldn't be registering to vote. And the last thing we want to do is put ineligible voters on the rolls, because they can have very serious civil and criminal consequences. But in any event, either that or to try to get grassroots voter registration organizations into high schools during lunchtime or at other times to staff a table. That's an important reform.
Let's go back for another question. I know I have one. Yes, sir.
Hi, my name is Andres Duran. I'm an attorney in San Antonio.
Hey, San Antonio.
We got to stop this Texas.
Anybody else from Texas? Anybody else from Texas? Only one? Oh.
Please tell your boss that this wasn't your fault, it was mine.
Right? He started
We didn't
it.
plan this.
He's just shaking his head. He's not even looking up at me.
I've been deeply frustrated by the voter ID fiasco in Texas. I worked the 81st session for Senator Shapley from El Paso.
Yeah.
And I recall how much of our resources and energy went into this ID issue and how many other issues, very important ones, we neglected during the session, which only happens in Texas for 2 years, because of this issue. And so maybe it's just my frustration, and I hope nobody takes it the wrong way, but would our resources be better used to try to get people IDs and just kind of go with that flow? And I hope I'm not saying that our efforts have been in vain, but from a utility perspective, is this something that we should consider?
No, you're absolutely right. If this lawsuit ends up saying that Texas can implement its voter ID requirement, that's exactly what everybody is going to have to do. And we'll be driving a lot of teenagers to the motor vehicles department and getting a lot of affidavits from old folks' homes saying, you know, because in order for an elderly, there's no elderly exemption. There was, it was stripped out of the bill. And so there'll be lots of getting affidavits from nursing homes and other places to try to prove up that a person should be able to vote without ID, and sort of all of that, absolutely.
And you know, when I was mentioning public education, this is what we're talking about. I mean, I'm going to be very clear. We do not think voter ID is appropriate. But again, we want people to be armed with information so that voters do not have their right to vote taken away from them. We don't want voters to stay at home because they fear that they don't have the requisite requirements. We want them to be armed. The Congressional Black Caucus had actually its inaugural convening of faith leaders from across the country. They brought together about 3,000 leaders about a month ago. And one of the key things that those leaders were asking is, okay, we don't like this. We think this is wrong. We don't want this to be in place, but tell us how we can arm our parishioners, the advocates and the community members who live around our churches, so that they can be in compliance. So that's part of it. It's talking to those faith leaders. It's talking to those community advocates and saying to them, these are the things you need to know. Here's how you can help your parishioners, your community folks get the requisite ID that they need. That's going to be key.
Secretary Dunn.
Well, and it's as simple for us is no disenfranchisement, no cost. And then if we are able to meet those standards for a voter, then yes. And we as secretaries across the country are looking at ways by trying to use technology, electronic poll books. Minnesota is working with yeah, you are right. I think you do have the most strict law in Texas. But Minnesota is working toward the e-poll books that a picture might show up, learning more about that. But that's one way that we are able to use the technology that we have. But no disenfranchisement and no cost. And then, as you talk about, use those efforts to make sure that folks are able to vote, and maybe use the provisional ballot aspect.
And I think
Also.
it actually comes down to, and this stems directly from what the Secretary was saying, this isn't necessarily either or. So once
Right,
restrictive
right,
rules are put
exactly.
in place, absolutely organizations and individuals will be doing their level best to help eligible citizens respond to the regulations in place and to deal with whatever the landscape is so that they can actually vote and vote effectively. But don't make the mistake of assuming that these regulations are the last stop and that if only we get past this one, there will be no further. Nate Persley and Stephen Salabaher have done a magnificent study in the Harvard Law Review a few years ago about perceptions of voter fraud, or perceptions of disenfranchisement, perceptions of problem with the system. And it turns out that if you believe there are huge problems, you believe them no matter what the identification landscape. And if you don't believe there are huge problems, you'll believe that things work out pretty well no matter what the identification landscape. So these laws, I think, and there's an issue brief that I've got out now through ACS, and thank you for that, that tries to bring regulation back to not only no cost, but to bring back to hard-nosed analysis of costs and benefits that the current debates seem to have been lacking. And so I think without the focus not only on responding to the regulations as they come out, but on re-bringing legislators in the states back to an assessment of costs and benefits, we lose sight of regulation that's really free from an assessment of the real costs on individuals that isn't constrained to voter ID. That is, it's not a question of, if we let this happen and just respond to the need at the end, can we finally be done with this conversation and get on to something more productive? This is about bringing the conversation to something more productive, about really assessing when we make new policy, when we put new principles in place, how are they treating the voters, and does this make sense? That's what the fight's about, not about one particular rule.
I just wanted to add, you know, there is this sort of very practical appeal to the question you ask, and I think one thing that flows from that is why then are these organizations fighting so mightily against the implementation of photo ID measures? And our past Director Counsel John Payton, he presented this very sort of salient picture for me of what photo ID measures do and who they impact, and he focused on Hurricane Katrina. And folks remember that Ray Nagin at some point was very vocal. It was not entirely clear when he was vocal, probably not vocal when he should have been, but at some point he's very, very vocal And he was telling people that this storm is coming. The storm is coming. It's going to be a disastrous storm, unlike one we've seen ever in New Orleans, and folks need to evacuate. And the warnings kept coming, and he implored folks, more and more vigorously to evacuate. The lower Ninth Ward is going to be a disaster. The storm is coming. Evacuate. Whether or not he had a plan for evacuation is another matter. But there was this, he was imploring people to evacuate the lower Ninth Ward because the storm was coming. And after the storm hit, folks now know that there were lots of folks who actually did not leave the lower Ninth Ward. And it is because they actually could not get out of harm's way. And it's that community, it's those folks who are the ones without the photo ID measure. There's studies that show, there's those folks without photo ID. There's studies that show that as many as a quarter of African Americans don't have photo ID. And for many in this room, right, folks travel quite a bit. If you enjoy alcohol, I'm sure that, somebody might flatter you and ask you for an ID at some point. But the reality is that there are lots of people who are far less mobile, who are far less integrated into our society. There are people who have been so pushed to the margins that even when a tragic storm is coming, they can't get out of harm's way. And so that is the reason why these organizations have dedicated so much of our time, forsaking sleep, to push back against these laws, because we know who they impact, that there are real people there. But at the same time, I think your point is well taken, and this goes to Nicole's point, that we have to reach those societies, those portions of our society that have been so marginalized that they don't have these mechanisms to fully participate in the political process.
And just real quick, I think what we could look at too is Rhode Island. I'm following it a little bit. I'd like to be able to see, how but they are going around in mobile offices giving free IDs. Oh, yeah. Now, Rhode Island is way small. I think even smaller than West Virginia, yeah. So, and not as, not as much terrain like we have. So I'm looking forward to that, and I'm sure that you all are going to be evaluating how do you measure the success, though? I mean, how do you know who didn't get one would be the question.
We have 70 counties out of our 254 that do not have a motor vehicles department office. So for those who will require, who live in those counties, they will have to drive to another county. And gas is expensive.
Mm-hmm. Yeah, this fight is not the same across the country. Circumstances very different in Texas than they are in Rhode Island, and the rules are very different. This is not a uniform fight against uniform laws. Some of them are actually much worse than others, and that, I think, drives where people choose to engage and where they choose to fight, maybe at multiple points. I want to go, we had a question over there. Yes, ma'am.
I'll be quick. I'm Lois Schiffer, first Secretary Tenant. We're all trying to enfranchise people so they can vote for people like you. You've been terrific. My question is, what are the plans for dealing with students who go back to college in September, want to register where they're in school, and suddenly face problems? And this is a 2012 problem to start out with.
Anyone in particular?
Well, I just want to say this. Unfortunately, none of us represent any of the student organizations, but there are organizations like Rock the Vote, and they were actually clients of the Brennan Centers in our recent Florida litigation, the litigation where the court just said, that part of the Florida law is unconstitutional, where they've made it harder for third-party voter registration organizations to come in and register people to vote. Helping organizations like Rock the Vote to be able to continue to be in the states to do their registration is going to be key, because there are specific organizations in place that are focusing on the students and ensuring that they have the information they need and are able to register to vote and know what the particular regulations are in their states.
And something else to mention in addition to all of that, and Lois, I know you know this well, for those of you that are heading back to campuses, whether you're faculty or students or merely living in the neighborhood, there are provisions of the Higher Education Act that are widely underreported, that actually require universities, if they receive federal funding, and that's every university out there essentially, to make voter registration forms available to students. And the most effective time to do so is right when students come back to register for classes in the fall. This is something that every single person who's heading back to a university or university town can be working on this summer in order to make effective come the fall registration season.
Well, but they may not have the ID to vote in Texas. If they have a student ID and they don't have a Texas driver's license, they'd better have a passport, a concealed handgun license, or a citizenship certificate, which costs about $300. So it's not like, some people get them, but, they cost money.
Where Second Amendment rights actually further the First Amendment.
Yeah, exactly. So the registration piece, yes, definitely possible and should be more available. The ID piece, it depends on your state.
Well,
Secretary.
for us, absentee ballots, we push that you can use an absentee ballot. That is a reason for having absentee. I'd like to see no excuse absentee ballot, but we don't, there are 31 states that have that. We're not one of those, which brings another little aspect in our state. Early voting, we do have early voting in West Virginia. But what we also remind, and reminding the faculty as well, that a student, they may want to watch if they're changing their registration from their home county to where their college is or university is, because they may have gotten a scholarship that was only for someone from Clay County. So don't hurt themselves in changing their registration to vote within their county, within their university.
And these rules vary widely from state to state on
Yeah.
where you happen to be eligible if you're a student, whether it's possible to vote from college or not. In many states, it is, but there are certain restrictions to keep in mind. The Brennan Center has actually put up, and I hope it's being updated, has from 2008 a guide to student voting that helps walk through some of these questions. What are the consequences of choosing to register in a different place? When can you? In which states can you? It's an enormous resource for people to look to. I think we've got time for one last question. I'm going to go right back to the center over there. Yes.
So I live here in the District of Columbia, and it is wonderful to be able to vote, but tragically we have nothing to vote for. And so I wonder if any of you had any ideas about how to fully enfranchise the almost million residents of the District of Columbia.
That's another panel.
Well, you do have a Secretary of State, actually, from the District of Columbia. Cynthia is the Secretary of State, which is interesting that, D.C. has one. So go ahead. Appointed by the mayor, as you know.
Well, fortunately, thanks to the 23rd Amendment, DC residents can vote in presidential elections, but, it did take a constitutional amendment to get that passed in, I think it was 1961. So, I think there's a question of whether this has to be done constitutionally, whether there's constitutional room for Congress to decide that DC can actually have taxation with representation in Congress and actually have a voting full member in both the House and the Senate. But that is another panel.
And with that, I want to thank you all and thank our panelists.